Well, we needed to tell the court what we are facing, but we are sorting it out. We are sorting it out. There's intervention. They have agreed. We are going to the office now to see whether we can get the document. So, well, that ends in the court. We have said what we want to say in court. We have said it. There are a lot of documents we need. We don't need to name them. There are documents we need. And it's not being denied that those documents they have or they don't have. So by the time we get there, tomorrow we'll be back. It's a serious business. This is our country. It's your country. It's my country. It's the country of everybody. So we need to get documents for the court to decide the justice of the matter. So that's why the lordships are also saying they needed cooperation. We needed cooperation. And that cooperation is what we have agreed will extend to ourselves. But as counsel, if we are faced with challenges, it's our duty to report back to the court, because we are not experts in jungle. We are lawyers, well trained, and we need to let the court know what we were going through. And the court had heard us, and their lordships have admonished us to do what we needed to do, and we will do it. I don't understand how crucial. He's a witness. So he's a witness. He is a witness. And he's a witness. So he has come. So he has not been discharged. So I do not have the capacity to determine whether the witness is crucial or not crucial. All we need to do is to produce evidence for their lordship to decide whether the witness is crucial or not crucial. It does not lie within I am doing my case. We are doing our case. There are allegations. We are bringing evidence that we think are relevant for the court to determine. So the court will look at it. But to answer you that is crucial, it will be, assuming a function that I'm not qualified to perform.
Thank you.
Thank you.